What do you make of both the Supreme Court's decision and how long it took to make it?
Well, I think the shocking part for me was it's not so much that they took it, it's the delay in how they took it. Just remember, if they were going to take it, they could have just granted Jack Smith's request to hear it from the district court. Remember, he had made an application saying, you know what, just hear it directly. If you want to hear this and you know you're going to decide it because you really feel like the Supreme Court is the one that has to lay down the law here, just take it directly from the district court. They said no. So you already built in all the delay at the Court of Appeals. Then there was this application to have it heard, and this sort of thinking was, well, it was taking them 2 weeks just to decide, and the thought was they're going to say no, because why would it take 2 weeks? So you're either going to take it or not. So I think it caught a lot of people, including myself, by surprise. And then the third piece is the schedule they set, because we're here at the end of February, and they're not going to hear it until the end of April. So all of that is a lot of time when you're looking at the clock, which is that Judge Chutkan had said this trial was going to be in March. And this clearly is saying, we really don't care about your schedule. And it may bump against the election or not. And that's really what's in jeopardy today.
But what about on what grounds are they deciding to hear this, right? We were waiting and waiting for those 3 circuit court judges, right, that panel. And when we finally got their ruling, you said, well, they took their time because they wanted this to be airtight. They have given a gift to the Supreme Court that there are absolutely no openings. The Supreme Court can't possibly say, we're going to want to hear it. But alas, they did.
Well, on the merits, so there's sort of 2 pieces. There's the merits and then there's the timing. On the merits, you could have the court ultimately say there's no presidential immunity as a principle. But in fact, they will be giving Donald Trump immunity because he will not be able to have a trial before the election. So if he wins the election, he de facto is immune.
My gosh, Glenn, is there any precedent for a president having complete legal immunity? Because for the average person listening to Donald Trump speaking at the podium, he acts like it's a given.
Yeah, there's no precedent. Even in the civil context, he doesn't have absolute immunity against civil liability. And there's been no precedent at all regarding whether a president is immune from prosecution. There is some precedent that he's not immune from criminal processes like subpoenas, having to comply with subpoenas in criminal investigations. By natural extension, you would think he wouldn't be immune from prosecution. Indeed, even the Constitution says that even if a president is impeached, he can still be prosecuted for the same conduct. So it's a head scratcher as to why they are accepting review of the case. But I couldn't agree more with Andrew. The way they just sort of casually sold American democracy down the river by putting this off for 2 months down the road when they could have taken this up just 2 weeks from now, Steph, what they have done is all but deprived the American voters from knowing whether, when they go to the polls in November, assuming Donald Trump is the Republican nominee, they are voting for a convicted felon or somebody who has been fully cleared by a jury of his peers, found not guilty on all charges. I think the American people are entitled to know who they're voting for. Somebody who tried to overturn the last presidential election or an absolutely innocent man. And the Supreme Court has all but taken that away from the American voters.
Susan, is it fair to say that this will be one of the biggest decisions in our court's history? What's at stake here?
Look, the election is at stake. A view of American democracy is at stake. The legitimacy of the Supreme Court, by the way, is at stake. And I know that Justice Roberts, the Chief Justice, is often reported to be someone who cares very much about the legitimacy of his institution. He appears to have, really dealt a blow to the credibility of the institution. You have great legal experts on here. I'm not that. But I have to say, my immediate thought turned to how quickly the Supreme Court was able to move in Bush versus Gore back in 2000. I thought back to, when I was just a little kid and the Nixon Watergate tapes. the Supreme Court moved with lightning speed to decide that. If this isn't a kind of commensurate emergency, in my view, it's actually a much greater emergency, because not only are the credibility of our institutions at stake and individual laws, but the very question about whether the United States might elect someone who would be a felon for the first time in history. Donald Trump is the first former president to have been indicted, and the idea that Americans are going to go to the polls without really understanding whether he's guilty or not of the crimes he's charged with, which are crimes against our democracy. I just find this to be a very big moment. In 2024, I'm not sure we're going to have many other big days that are bigger than this one.
Oof. Andrew, what would it mean if the highest court in the land decides that a president of the United States is immune from any and all prosecution?
Well, you know what? Even though I'm very pessimistic about what happened today in terms of whether it will get to trial, I'm, maybe call me like an optimist on this point. I just don't think that's going to happen. I do not think there will be 5 justices who say that he is immune in this circumstance. The idea that you could engage in criminality involving the overthrow of an election, even if they say we're not going to say you're sort of have immunity for everything, I just can't imagine for this that they're going to say they'll have 5 votes. My biggest concern is that they de facto have said that, because they might write a very flowery opinion that we all sit around and go, isn't this wonderful, about how they're upholding the rule of law. But they will have been, in fact, denying the rule of law in this case by not allowing a trial to go forward. Because even though we can all look at the facts, so the way sort of disputed issues are decided in this country is they go to court and people can assess the facts, a jury can hear it, the American public can read about it, and that's the way we decide things. And I think that is what's being deprived now.
Glenn, Donald Trump's attorneys are going to be arguing this before his legal fate in front of these 9 justices, 3 of them appointed to the bench by Donald Trump himself. Is there any chance that we see any of the 3 of them recuse themselves? I haven't even mentioned Clarence Thomas. That's a whole other thing.
What a quaint notion that a justice who has the appearance of a conflict might feel compelled to remove themselves from the case. Recusal doesn't seem to be a thing anymore, Steph, although when you look at the federal law, the bar to have a judge be required to remove themselves from a case is actually pretty low. It just says if the judge's impartiality might reasonably be questioned. Might is not all that high a bar, and reasonableness is an objective standard. I maintain that there are any number of legal experts far smarter than me that have questioned the impartiality of people like Justice Thomas, of people like Judge Cannon down in Florida. Have we seen a recusal? No, we sure haven't, and I don't think we should expect to see one anytime soon.